Good day, wherever you are, whenever you are. My name is Charlie Rose, and this is The Trial Advocate, a series of videos and presentations designed to assist you, the practicing attorney, in understanding completely your responsibilities under the professional responsibility rules of your particular state, or in guiding you from a procedural or substantive law perspective in the representation of those with whom we have an attorney-client relationship. This is also a great resource that can be used potentially by law students who are preparing for professional responsibility exams, who are getting ready to take the MPRE, who are involved in evidence classes, or who have a trial act class or a pretrial class, and they need to brush up on some skills. You should think of it as for want of a better word, it's a flash drive from my mind. What I'm trying to do is to take about 30 years, 25 or 30 years of legal experience and condense it into a series of lectures and presentations that supplement the speeches that I give nationally and that are there for you wherever you might happen to be. And the reason that I'm doing them is because I think as a goal of my scholarship and of my outreach and support of trial lawyers, I want to make certain that as many resources that are free are as available as possible to help you in the moment. They're all going to be stored in various places on the web, not on the dark web, mind you. At least I hope not, dear God. And they're going to be here for your use. If you see something that's interesting, if you have further questions, you can always reach me by email at chroseii@thetrialadvocate.com or crose@law.stetson.edu. I'd love to have those digital conversations. It's kind of the way we all together kick the can down the road for the next generation of trial lawyers. And trial lawyers are, of course, some of the most important lawyers because they're the ones who stand between an individual and another individual or the awesome power of the state and say, no, wait a minute, the rule of law is going to apply here. And we're going to have process because it is in process and the rule of law that we ensure that we give democracy to the next generation. So what I want to talk about today in this particular module is a series of presentations about professional responsibility. And I'm coming at it from the idea that there are four primary pillars of professional responsibility that you need to be concerned with. And these four pillars encapsulate the entirety of any code that you might be involved in from a professional responsibility perspective that you might need to refer to. And learning professional responsibility and ethics and the formation of professional identity is one of the most important things that a lawyer does, and it's one of those parts of ourselves as attorneys that we need to always go back to and look at again so that we're dealing with it appropriately. And the reason for that is because we train in a particular fashion, we study law in a particular fashion, we work in particular fields. And as we work in those fields, over time we accumulate knowledge, we develop patterns of behavior. And then when an issue occurs, we respond in the moment based upon our conditioning. You train the way you fight and you fight the way you train. And so because ethical violations and ethical issues are endemic, and you're going to see them in practice, you need to have thought about it. You need to have thought about it in a time and a place where you were allowed to be reflective on it. And that's important because if you do that ahead of time, when the time comes, when the moment arises, when you have to make that on-the-spot decision, it'll be an informed decision. And by being an informed decision, that means that you're going to be okay. It means your client's rights are going to be secured to the maximum extent possible from a legal perspective. Your license is going to be preserved, and maybe you'll even get paid. And all of these are good things, right? So I've got four primary pillars of ethical lawyers that we need to be concerned with. There's regulation of the profession, lawyer-client relationships, conflict of interest, and the duties that a lawyer has, both to their client, to themselves, and to other individuals involved in litigation. And what I thought we'd do in these particular series of the Trial Advocate lectures is go through and look at the substantive black letter law. We would compare that black letter law and juxtapose it to a series of common sense for want of a better word, scenarios where the law needs to be applied. And then maybe from it together, we might be able to posit some places where we need to be mindful, where we need to have been thinking about something both on the surface and underneath the surface before it happens, so that we respond appropriately in the moment, whether that's in the courtroom, the boardroom, a client meeting, in a conference room, talking to another lawyer, being approached by a judge. In all those instances, we'll know what to do. And it's important that we know what to do, because we, as members of a self-regulated profession, are the ones who are going to determine whether this profession continues to remain self-regulated. And we're the ones who are going to set the boundaries and the requirements and the responsibilities for how we're going to practice and how the people who come after us are going to practice. And because these issues are really important to us, they're phenomenally important to us as a profession, we need to think about them. And our thought process should begin with a review of the law. So let's get started on that. The first rule that you often run into when you are a trial advocacy student, a professional responsibility student, or when you're a law student, is how the heck do I get to be a member of this profession? How do I make it through that door so that I have the privileges, the rights, and the responsibilities that are accorded to every single lawyer? And that's an important thing for those of you who are studying law right now. And it's a precious thing for those of us who are members of a bar. Because being a lawyer is not a right, it's a privilege. I'll say that again, it's not a right, it's a privilege. And because it's a privilege, the bar has the ability to screen you. In fact, their responsibilities to the republic and to the public members of our democracy require them to screen. And they require them to screen because, quite frankly, you have phenomenal power as an attorney. You have the ability through the rubric of the law to change and destroy people's lives for both valid and invalid reasons. And so we want to make certain as you begin your journey as a member of the profession, that we've looked at what's required to be a member of the profession and that you meet those requirements. And we'll start with Rule 8.1, bar admission and disciplinary matters. When you're applying to the bar, you may not make a false statement of material fact. So you can't lie affirmatively about a fact that the bar has requested. And doing so can prevent you from being admitted to the bar. You also can't lie by omission. And that's what 8.1b is talking about. That's where you fail to disclose a fact necessary to correct a misapprehension, or you knowingly fail to respond to a lawful demand for information. So I can't ignore it when they ask me for something. I can't lie about it by omission, and I can't lie about it affirmatively. And if I do these things, I actually create a great deal more difficulty for myself in becoming a member of the bar. And the reason that I do is because this duty of self-disclosure is going to be compared when you go through the bar application process. And they're going to look everywhere that you've disclosed it in the past to see if you have been internally and externally consistent. This means that law students need to compare their answers on their law school admissions file with what the bar in their particular state asks them. And they need to deal with any discrepancies. And if there are discrepancies of a material nature, they might have to file an amendment with their law school on the law school application. And this can create a lot of confusion, particularly right after a student has taken a professional responsibility course. First thing a student in that situation might want to do is to talk to an attorney. You'll notice in Rule 8.1b, it says, this rule does not require disclosure of information otherwise protected by Rule 1.6. Now, Rule 1.6 is the rule of confidentiality. It's the rule that says that I can go to a lawyer, I can discuss an issue with them, and they have to keep my confidences and may not disclose unless I give permission. And we'll talk about Rule 1.6 in another presentation. But in a nutshell, they're bound by attorney-client confidentiality unless you tell them you're going to go commit a future crime and they're reasonably sure it's going to result in death or grievous bodily harm. And then there's some ability to disclose if they're using your law firm to perpetrate a fraud, and there's some ability to disclose in a couple of other instances. But you know where there's not an ability to disclose ever? If I, as a practicing lawyer, have as a client another lawyer or potential lawyer who is dealing with a professional responsibility issue, and they come to me for legal advice, they want to know, what are my options? Should I disclose this? Is this a material fact? Is this something that I've knowingly made a false statement about? They can tell me what happened. I discuss it with them, and it stays in my lockbox, to use an Al Gore phrase, forever. I can't unlock it. Not only can I not unlock it, but the Florida bar can't unlock it, or the Alabama bar, or the California bar. We so desperately want lawyers to run by other lawyers their concerns about ethics and to get competent legal advice, that we give them this blanket coat of confidentiality. And it's one of the most interesting pieces, quite frankly, of attorney-client confidentiality and of application for admission to the bar. What this means to you is that you could always go to another lawyer to get advice about ethical issues, and you never have to worry that that lawyer is going to disclose to a third party what you've told them without your permission. And that's a big deal. You have to have that sort of safety valve in order for a self-regulating profession to work. If you don't have it, you create an environment where no one trusts anyone, no one discloses anything. The knowledge of a generation is lost to the next generation because nobody's talking. And we want the exact opposite of that to occur. And this is one of those places in Rule 8.1 where we see that happen. If we move a little further, we go and look at Rule 8.3, reporting professional conduct. And there's a couple of things here that I'd like to point out to you. 8.3a tells us that a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question, so that's the test, raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, shall inform the appropriate professional authority. Well, if we were in a PR class, I'd tell you to circle the word shall, because that removes from the purview of the lawyer the ability to weigh and say, well, maybe I will, maybe I won't. And then I tell you to circle raises a substantial question, because that's the pivot pin. That's the hinge upon which this particular rule turns. And it's in the interpretation of whether or not a substantial question has been raised that we often find ourselves dealing with interesting issues as attorneys who observe what may be misconduct on the part of others. We have a duty to disclose to the bar. This is often referred to as the rat rule. I'm going to rat my buddy out, which is unfortunate. What it's actually doing is it's putting our ethical license on the hook if we know of ethical misconduct by another attorney and we don't raise it to the bar's attention. But at the same time, it's telling us, hey, look, it has to be a substantial question as to their honesty or trustworthiness or fitness as a lawyer. And it's not a substantial question that they've upset you, that they pissed you off, that they beat you in court, that they acted in an uncivil fashion, although there is a remedy for that as well. It has to be that we're worried about their ability to interact with the public, to represent their clients, to perform the basic functions that a lawyer has to perform. And those functions have to be performed in an honest, trustworthy, and fit manner. And that's really what this rule is looking at. If we were to go to look in the comments of the rule, regardless of the jurisdiction where you're in, we would see that the bar pulls back on this mandatory reporting requirement and gives guidance and places conditions on it that any good lawyer could walk through from a loophole perspective, unless it was perhaps your supervisor or your subordinate for whom you also had some other ethical relationship through Rule 5.1, 5.2, or 5.3. In those instances, 8.3 might come back and become an issue for you. The other thing about Rule 8.1, 8.3, and 8.4 that are interesting, at least tangentially, is that these rules rarely form the basis for an ethical violation, an ethical hearing. And they rarely form on their own a substantive reason to reprimand someone, suspend someone, or remove them from practice for good. They are usually presented in concert with one of the other substantive rules that we'll talk about a little bit later. Now, Rule 8.4 tells us that there are some things that are professional conduct, and this is sort of like a catch-all rule. What it's telling us is that if you violate the other rules of professional responsibility, that can itself be considered professional misconduct as well. So that's violating the rules, trying to violate the rules, knowingly helping someone else do so, or asking someone else to do so. You cannot ask someone to do what you yourself are not allowed to do, particularly if there's any kind of agency or employment relationship between you and the person in question. You also cannot commit a criminal act that reflects adversely on your honesty, trustworthiness, or fitness as a lawyer in other respects. And that criminal act commission rule is actually relatively broad. And there have been cases where lawyers have gotten in trouble for conduct that was arguably relatively far afield from the practice of law. And the reason that those generally happen is because, quite frankly, what the bar is concerned with is the way in which the public perceives you as a member of the profession, and the way in which your actions or activities reflect back on the self-regulated practice of law. And so there are things that may only be tangentially related to the actual practice, but that are going to get you in trouble if you engage in them. I tell my students in professional responsibility classes and in other situations, the things that get you in trouble are sex, drugs, and some version of rock and roll, some version of misconduct, right? Money gets us in trouble, improper sexual relationships get us in trouble, and abuse of substances such that it affects our fitness or perhaps flows back into the money or the sex issue. You can almost see that triad of issues circling around most lawyers who find themselves before the professional responsibility board or commission, disciplinary board, depending upon how your state sets it up. Every state has some version of it, as part of a self-regulating entity, normally falling underneath the auspices of the Supreme Court because it's a judicial function as opposed to an executive function or a legislative function. Some other things that you can't do is you cannot engage in conduct that is prejudicial to the administration of justice, and you're not allowed to state or imply an ability to improperly influence a government agency or an official, or to achieve results by means that violate the rules of professional conduct or other law. In other words, I cannot use my knowledge of the law and the loopholes of the law improperly to violate them myself, or to have another person violate them on my behalf for the benefit of myself or the benefit of the client. And if I do so, that is in and of itself a violation of the rules of misconduct under Rule 8.4. And I'm also not allowed to help a judge do that sort of thing. So when you bribe a judge, the judge is in trouble and you're in trouble. You both go down for the bribe, not just one of you. You're not allowed to get the judge to do something wrong and then step away, go, hey, wait, he's the judge, not my fault. I might have suggested that he do something improper, but that's a grown person and it's their choice. That argument is not going to work. It's not going to be effective. If we go and look at the commentary, and I wanted to point this out to you because when young lawyers or students first read or look at Rule 8.1, 8.3, and 8.4, they think, my God, I can't do anything. I could be in trouble, and I've got to always be watching my fellow lawyers, and then I have a duty to report, and if I don't report, I'm going to get in trouble if it's later found out that I knew about it, and oh my God, what should I do? Maybe I should go to dental school. And if we back up a minute and we look at the commentary, if a lawyer were obliged to report every violation of the rules, the failure to report any violation would itself be a professional offense. Such a requirement existed in many jurisdictions, but it actually was unenforceable. This rule limits the reporting obligation to those offenses that a self-regulating profession must vigorously endeavor to prevent. A measure of judgment is therefore required in complying with the provisions of this rule. The term substantial, remember we talked about substantial in Rule 8.1, refers to the seriousness of the possible offense and not the quantum of evidence of which the lawyer is aware. So you've got to have some degree of quantum of evidence, you've got to have some degree of seriousness, and these two balance together to help you decide what to do. Well, guys, in conclusion, I have talked with you in this particular block about entry into the profession, Rule 8.1, 8.3, and 8.4. Your states, regardless of where you are, have an analogous rule. These rules actually come right out of the ABA model rules. Of course, I don't use the ABA model rules in a presentation like this because the ABA, in its infinite wisdom, makes people pay to use their rules. I am instead using the Delaware Rules of Professional Conduct, and the reason that I'm doing the Delaware Rules of Professional Conduct is because they mirror the ABA rules and they're public law, so they're free. And the law should always be free. Till next time, I'm Charlie Rose, and this is the Trial Advocate.